Hey everybody, welcome back to Girl Talk. Thank you so much for joining me. As always, before we get started, if you can give me a like, share, thumbs up, comment, all that other good stuff, I would appreciate it. So we're going to get right into, what are we at now? Day 21 of the Lindsay Clancy trial. This was from yesterday. So put my readers on here. This is ridiculous that you have to wear readers with contacts. Don't ever get in your 40s, guys. All right, so the first witness was Dr. Gregory Sathoff. He was the rebuttal psychiatric expert, and he was called by the Commonwealth. He says the defendant reported a voice, but voice did not tell her where to kill the children, how, what to use, in what order, and where or how to kill herself. Doctor states significance. Absence of instructions show defendant made her own decisions, acted quickly and methodically, handled unexpected phone call. And I believe that was the one where Patrick had called me. Oh my gosh. Patrick had called her when he was out of the house. Patrick did not call me. Indicates defendant had control of sequence. Interpersonal psychological theory of suicide explained. Aloneness, burdensome, and capability. Applies theory to defendant. Documented isolation, burdensome due to inability to work and financial stress. Capability shown by serious suicide attempt using 3 methods. Ativan relieved intrusive thoughts. Ativan is not antipsychotic. It supports internal thoughts, not external hallucinations. Psychosis does not prevent knowing right or wrong or conforming behavior. Opinion. Defendant had mental disease defect, bipolar 2, but still appreciated right from wrong. Medication review. Insomnia from Zoloft was an adverse effect. No evidence of overmedication except Seroquel dose she never took, and amitriptyline was a low dose of 10 to 20 milligram. His opinion was the defendant appreciated right from wrong, and his basis for that. Denied suicidal ideation to psychiatrist the day before. The planning searches for 3V distance and CVS. The 3V distance, don't forget that was the restaurant. Avoidance of witnesses. Concealment. Basement strangulation. Office door was closed. She had timing awareness. The exercise bands were placed near the children. No delusions about children. Phone call concealment. Locked door to delay discovery. And she expected to die before the husband returned. And his opinion was that the defendant could conform behavior to law. The pediatric appointment behavior was normal. Controlled activities all day. Methodical planning. And phone call concealment ensured husband stayed out. His final opinion was the defendant criminally responsible, and the Commonwealth moved to admit Dr. Sathoff's testimony, admit it, and then the direct ends. So then we had the cross-examination, which was by the defense. Engagement and compensation. Doctor engaged January 2026. Contract finalized April. Doctor does not know payment amount. The university was paid. Timing of evaluation. Incident was January of 2023. Doctor evaluated May to June of 2026. Defense argues evaluation was too remote. Doctors' backgrounds. Defense reviews extensive CV, worked with prisons, Department of Justice, FBI, terrorism studies, extreme violence, hostage negotiation, threat assessment. Objections sustained to quote-unquote government man. Postpartum experience. Doctor treated postpartum psychosis decades ago in a state hospital. Defense presses lack of recent postpartum specialization. And I want to put my thoughts on this for a minute. Now, they're saying that, where was it? He treated postpartum psychosis decades ago in a state hospital. Look how far that we have come with mental illness just in the past 10, 20 years. So he's going based on what happened decades ago? It's just my thought. I think if they were going to come up with a witness or an expert, they would have had someone that was up to date. That's just my opinion. All right. Intrusive thoughts and disclosure. Defense asks whether defendant told teachers, neighbors, doctor was unaware. Defense argues professionals should ask about voices versus thoughts. The Aspire hotline. Defendant called suicide hotline twice. Hotline redirected her. Doctor says lack of plan prevented hospitalization. Defense argues the devastating impact. Medication issues. Defense challenges medication interactions, breastfeeding sensations, progesterone drop, GABA dysfunction. Doctor acknowledges possibilities but not definitive. 911 call. Doctor admits defendant only made guttural sounds on 911 call. The defense challenges reliability of husband's recollections. And then the crushed pills. Doctor relied on husband's observation. No lab testing, no residue found, no pill crusher found. False memory. Defendant said she slashed screen. Screen was not slashed. Doctor says not malingering. Family misleading. Doctor says defendant portrayed herself differently to family. Defense disputes. Mother interview. Doctor attempted to interview mother. DA said she would not speak. Defense argues doctor should have contacted the defense. Rapport. Doctor says rapport established. Defense challenges sincerity. Malingering test. MMPI administered earlier showed no malingering. Dr. Resnick also found no malingering. Auditory hallucinations research. Defense cites Resnick/McCarthy Jones article. Internal versus external voices. And the doctor agreed that external voices can be legitimate. Prosecution opening statements read to witness. The defense reads prosecution's opening lines to doctor, and then the cross ends. So the exhibits that were admitted were Dr. Gregory Sathoff. His was admitted. No additional exhibits admitted. Introduced on day 21. The end of day administration. So judge schedules charge conference for 2:30. Defense renews motion for required finding. That was denied. Court recessed until 2:30. Afternoon session continues with cross-examination until conclusion. And that was it for the interviews. So let's get to some of these public opinions here. All right, so here's some interesting things that the public is saying, and this is off of Reddit. It says, I generally cannot believe how badly prosecution screwed up today. My jaw is still on the floor. And then somebody had comment, which part are you referring to? Slipping up that she had false memories of the event. If she has false memories, her confession cannot be trusted. The entire case is then built on Patrick Clancy's testimony, which was also called into question. No one else heard her speak immediately following, just gurgles. Only his fingerprints are on the exercise bands. They essentially cannot find her guilty now because prosecution handed them reasonable doubt on a platter. That's out. It'll either be mistrial, manslaughter, not criminally responsible, or not guilty. So there was another one, and this is quite interesting, I thought. It was a new commentator, and good question here. Someone in here said the district attorney now owns the Clancy house where this all happened. Is that for real? Like the elected team in charge of prosecuting Lindsay Clancy now owns their house? The literal scene of the crime? Has this been brought up in trial? It just feels like really weird and a possible extremely unethical situation to me. Could someone explain to me, like I'm 5, how that's anyway plausible or legal? I'm honestly shocked. Sorry. And then somebody said it's not the current DA, it's a former assistant DA who's now a defense attorney. The person who owns the house is not involved in the case in any way other than being forced to show the house to the jury. So then someone had said, what are the odds? Do defense attorneys / former assistant DAs normally buy homes associated with controversial murder cases? Interesting. Does the ADA, Jennifer Sprague, know him, or is it a former colleague with the person who owns the house now? I don't know. Maybe I'm crazy, but this feels so strange to me. And then this one says a diagnosis of psychosis or postpartum psychosis is medical evidence. It can support the defense, but it is not the legal standard. Prosecution experts have testified that she understood the act was wrong and that she retained enough control to carry out the sequence of steps. Defense experts have testified the opposite. Command hallucinations and a sense of being overtaken meant she could neither appreciate the wrongfulness nor stop herself. Massachusetts includes both the cognitive prong and the control prong. People often collapse it to knew right from wrong. And then here's another question about the former DA buying the house. I have a sincere question. Why did the former DA buy the Clancy house and then try to bar jurors from walking through it for the trial? My God. This ain't funny, but it said, I think they genuinely cannot read this morning, guys. Sorry. Didn't want to stampede in their new house and maybe to sabotage the bows. And then there was actually, it was on News Nation Now. It was an article, and you can look that up if you'd like. Like I said, News Nation Now. Seems like he thought it would be disruptive according to the article. Also saw this one in another article. Quote unquote, at the June hearing, Assistant District Attorney Jennifer Sprague, who is prosecuting Clancy, said Phippen knew when he bought the property in 2024 that there would be a jury view someday in the future. So they weren't happy with him trying to shut down the visit. I'm just looking through some of the other comments here. And we'll just go over a few of them. It says, I've said this before, but I'll say it again. It's insane how they have defied themselves and the prosecution as being the only ones who cared that Cora Dawson and Callan were killed. Their father, parental grandparents, maternal grandparents, aunts, uncles, friends of the family, none of them cared about or loved the children the way these random Reddit posters do. And they're insistent that Lindsay had a personality disorder or is a sociopath when she's taken multiple assessments administered by both the defense and prosecution experts, and none of them have diagnosed her with any sort of personality disorder. Their characterization of her as this evil, soulless demon is just so crazy. You can still think she was criminally responsible while also acknowledging she was severely struggling, which is even what the prosecution's expert said. And then this one says, do we think that there will be any objections in the closing arguments tomorrow? So that is today. So apparently closing arguments will be today. We'll see what happens. With it being Thursday, even if they do have closing arguments today, I mean, I think I read somewhere, I didn't get to listen to it all yesterday. I think somewhere the prosecution was asking for an hour and Big Red was asking for a half hour for closing arguments. After that, once the instructions are given, it should go to the jury. So maybe tomorrow, not sure. It might go into Monday. Kind of depends, but this should wrap up shortly, and then we can really have a deep dive and talk about what the verdict is. So thanks for joining me, guys. Stay tuned, and we will talk soon. Have a great day. Bye.